Good morning, students. The topic for the day is set off and carried forward of losses. As we have already done with the five heads of the Income Tax Act regarding salaries, house property, income from other sources, business and profession, and capital gain, now we are going to start with the loss treatment. So, Section 70 to 79 of the Income Tax Act deals with the provisions regarding set off and carry forward of losses. This is basically divided under two heads, two headings we can say, set off of losses or carry forward or set off of losses. Now, what is set off of losses? When any loss relating to any particular previous year is set off against the income of that same previous year, it is known as set off of losses. Set off of losses is divided into two parts: inter-source set off of losses and inter-head set off of losses. Section 70 of the Income Tax Act defines about inter-source set off of losses, which says that if a person suffers a loss from one source, that loss can be adjusted against the income from another source. Suppose Mr. A is having two businesses A and B. He suffers loss from business A and earns profit in business B. Then, while calculating his income under the head profit and gains, he can adjust the loss which he has suffered from business A from the income from business B. So this is also known as intra-head set off of losses. Intra-head means within the same head. But there are few exceptions to this rule. That is, suppose you suffer a speculation loss. This loss can be set off only from the speculation gain if you earn any of it. But any loss from any non-speculative business can be set off from speculation gain. Similarly, if a person suffers a loss due to expenses on maintenance of horses for race purpose, the same loss can be adjusted only from the race course winnings and not from any other income. Inter-head setup of losses means when loss of one head of income can be set off against the income from another head in the same assessment year, except in case of speculation losses, loss from owning and maintaining of race horses, loss under the head profit and gains. This cannot be set off from income under the head salaries. No loss can be set off from the casual income. Then loss under the head house property can be set off against income of other heads only up to 2 lakh rupees. And in case of capital losses, long-term capital loss can be set off only from the long-term capital gain, whereas short-term capital loss can be set off from short-term capital gain as well as long-term capital gain. What do you mean by carry forward and set off of losses or set off of brought forward losses? Suppose any loss relating to any previous year is not able to be set off either under the same head or against income of any other head during the same previous year, that loss can be carried forward in the future previous years for setting off against income in such future previous years. This process is known as carry forward and set off of losses, and all these is done according to the provisions which are prescribed under the Income Tax Act. Accordingly, certain losses falling under various heads of income are allowed the benefit of set and carry forward of losses of against income of future years. The provisions for carrying the loss of one previous year to the following previous year and adjusting it are: number 1, there can be no loss under the head salaries. Number 2, house property loss can be carried forward for 8 succeeding years to be set off only from the house property income. Third, the business loss again can be carried forward for 8 succeeding previous years to be set off from any business income. Even the loss of a discontinued business can be carried forward and set off up to 8 years. A business which is set up under section 35 AD, which is known as a specified business, can carry forward their losses for an indefinite number of years, but it can be set off only from profits of a specified business. In this case, the return of loss must be submitted on or before the due date. Then, in case of an unabsorbed depreciation, which remains unadjusted because of want of profits or because of less income in the relevant previous year, can be carried forward till it is fully adjusted in the succeeding previous years. And in that year, it shall be treated as the income or depreciation of that previous year. Speculation loss can be carried forward for 4 previous years to be set off from the speculation gain only. Then, if we have a capital loss, which can be short-term capital loss or a long-term capital loss. So, short-term capital loss can be carried forward for 8 succeeding previous years to be set off from both short-term capital gain or long-term capital gain. But in case of a long-term capital loss, it can be carried forward for 8 years, but it can be set off only from long-term capital gain. Then, if we suffer any loss because of expenses incurred for maintenance of horses for race purpose, it can be carried forward for 4 succeeding years to be set off only out of the winnings from races. There are some special provisions relating to set off and carry forward of losses relating to firms. So, for under section 75 deals with the loss of firm. Suppose a firm suffers a loss from a house property. Such loss can be set off from firm's income. Otherwise, what happens is that house property loss can be set off only out of the house property income. But this special benefit is allowed to firms only, that they can set off their house property loss from their firm's business income. Then, firm cannot treat their loss as a loss of the partner. That means the share of loss of firm cannot be set off from the partner against his individual income. Then, if a firm suffers a loss and there is a change in the constitution of a firm, constitution of firm here means that change because of retirement of a partner or in case of death of a partner. This provision is given under section 78. In such a situation, when any such change occurs, the firm is entitled only up to the share of that deceased or that retired partner. You cannot charge, you cannot set or carry forward losses more than the share of such type of partners. Then, if there is a succession in your business, succession here means when one person succeeded the other person in the same capacity, otherwise then in inheritance के अलावा, ठीक है, In such a situation, uh, what happen is you can only set off and carry forward losses only up to your share. You cannot, yeah, you are not entitled to carry forward or set off the losses of your predecessor. That is very, very important. So the successor in the business is normally treated like he has just commenced a new business. There are certain provisions under Section 72A relating to carry forward and set off of accumulated losses and unabsorbed depreciation in case of amalgamation or demergers. So, if there is an amalgamation of a company owing an industrial undertaking or a ship or a hotel within another company, or in case of a banking company with a scheduled bank, or in case of a public sector company engaged in a business of operations of an aircraft within another public sector company engaged in such type of a business, in such type of amalgamations or demergers, the accumulated losses and the unabsorbed depreciation of an amalgamating company shall be deemed to be the loss of the amalgamated company, so they can adjust accordingly. There are certain provisions under Section 72AA relating to carry forward and set off of accumulated losses and unabsorbed depreciation in case of amalgamation of a banking company under the scheme sanctioned and brought into force by the central government under the Banking Regulation Act 1949. Actually, such type of amalgamation is when a banking company is amalgamated within another banking institution. In such a situation, the amalgamated losses as well as the unabsorbed depreciation of the amalgamating bank shall be treated as the accumulated losses and the unabsorbed depreciation of the amalgamated bank. In case of a company not being a company in which public is substantially interested, if there is a change in the shareholding during the previous year, no loss incurred in any year prior to the previous year shall be allowed to be carried forward or set off against the income of the previous year until and unless on the last day of the previous year the share of the company carrying not less than 51% of the voting right were beneficially held by such a person on the last day of the year in which the loss was incurred. The order in which current and the brought forward losses are to be adjusted out of the profits of the current year are: number 1, current year's depreciation, then capital expenditure on scientific research, then current loss of another business, then brought forward business loss of the earliest year, but the oldest loss is to be adjusted first, then the brought forward unabsorbed depreciation, and then brought forward unabsorbed capital expenditure on scientific research. Any questions? Thank you.